Hello students, how are you all doing today? I am Dr. Ankit Shrivastava, Assistant Professor of Law at RGNUL Punjab. Here we are today with another topic titled Nuisance and Environment Pollution. In the landmark environmental law case MC Mehta versus Kamalnath, it was noted that pollution is a civil wrong. Pollution is legally considered a tort, namely one that harms the whole society. Consequently, an individual who is convicted of producing pollution is obligated to provide compensation for the rehabilitation of the environment and ecology. Furthermore, apart from the aforementioned damages, the party responsible for the pollution may also be obligated to pay punitive penalties which are intended to discourage future activities that cause pollution. There is global apprehension over pollution. The primary factors contributing to environmental pollution are human actions such as trash and the poisoning of the environment by industries dealing with dangerous products. Individuals who engage in direct or indirect pollution have a significant influence on others. An individual's acts should not encroach upon the rights of others. Tort law aims to offer restitution to guarantee that those who have been harmed as a result of environmental damage are duly compensated. This lecture explores the use of tort law as a means of pursuing legal remedies. The Environmental Protection Act of 1986 is legislation that forbids the pollution of the environment. This legislation was enacted in response to the sad and horrible Bhopal gas tragedy. Despite appearing comprehensive in addressing issues such as air, water, and land contamination, the Environmental Protection Act has little practical effectiveness. Essentially, this means that tort law functions as a tool of correcting wrongdoing, but its primary purpose is to prevent harm from occurring in the first place. Victims of environmental contamination can alone pursue justice via litigation to get compensation. Moreover, this legislation establishes a loophole by allowing the offender ample time to eliminate any proof of their dumb behavior, since the 60-day notice requirement undermines the radical approach to the locus standi system, which pertains to the right to bring a legal action. Major enterprises such as chemical companies often contribute to environmental pollution by posing a threat to individuals and their assets. Individuals may find it challenging to embrace the safeguard offered by laws due to the exorbitant costs associated with litigation. Statutes alone are insufficient to ensure sufficient protection. Tort law is preferable for individual claims as it focuses on providing compensation to the injured party. Despite the passage of several years following achieving freedom, it continues to be efficacious. Thus, apart from legislation, tort law provides a lawful avenue for those harmed by pollution caused by another party to seek reparation. Nevertheless, it is widely recognized that tort law only applies to situations involving bodily injury or damage to personal belongings. Given that environmental pollution affects the entirety of the environment, tort law is only relevant in situations involving environmental damage. Now let's see what is environmental law all about. Environmental and natural resources law is a synonym for environmental law. Environmental law encompasses the comprehensive set of legal provisions including legislation, regulations, statutes, common laws, and customary laws that govern the impact of human activities on the environment. The primary environmental law regimes tackle environmental pollution. The Indian government enacted the Environment Protection Act of 1986 in response to the Bhopal gas tragedy. Before the formation of the EPA, laws mostly focused on certain categories of pollutants, such as those present in the air and water. The establishment of the EPA was prompted by the necessity for a singular organization that could assume the primary role in safeguarding the environment. It assumes the form of comprehensive statutes that establish the basis for the central government to oversee the activities of various state and federal entities that were established via prior laws. According to Section 2A of the Environmental Protection Act of 1986, the environment is defined as the combination of water, air, and land. It also includes the complex connections that exist among these elements and their interactions with human beings, other living animals, plants, microbes, and property. Additionally, it manifests as empowering legislation that grants extensive authority to the executive branch, allowing bureaucrats to establish essential rules and regulations. The legislation was enacted with the subsequent aims. Under this legislation, the central government has the authority to undertake all necessary activities to protect and enhance the environment. The Act sets out regulations for the permissible levels of environmental pollutants that can be released or emitted from various sources. Furthermore, it restricts the geographical areas where particular businesses, processes, or categories of industries may function while still complying with stringent safety rules. The enactment of the Act was intended to protect the environment, control the emission of pollutants into the atmosphere, and manage dangerous chemicals. The legislation sets down procedures and precautions to prevent accidents that may result in environmental pollution, together with remedial measures for such occurrences and severe sanctions for those who jeopardize public health, safety, or the environment. Now let's look into the aspect of environmental torts. Tort law primarily concerns adverse outcomes that cause injury to individuals, corporations, and property. Now the term property pertains to entities that are subject to legal regulations rather than tangible items. There is no established legal system that governs the Earth's atmosphere, hence tort law does not have jurisdiction over it. Tort law comes into play when a mistake has happened. Consequently, in cases of environmental harm, tort law will be applicable. Its emphasis is mostly on therapy rather than prevention. The focus is not on punishment but rather on making remedies. It is a method used to address pollution in the environment. Now let's talk about environmental torts in India. So environmental torts in India refer to legal actions taken against individuals or entities for causing harm or damage to the environment. These torts involve violation of environmental laws and regulations resulting in negative impacts on ecosystems, natural resources and public health. Prior to the Bhopal gas tragedy of 1984 and the Sriram gas leak of 1987, the Indian legal system did not fully recognize the application of tort law in addressing civil culpability in environmental conflicts. Environmental jurisprudence in India has developed by amending the substantive locus standi law of the Constitution and using the public interest litigation or social action litigation method. This legal framework is primarily based on the Constitution of India and the statutory context outlined in the Water Pollution 1974, Air Pollution 1982 and the Environmental Protection Act of 1986 among other matters. Within the realm of environmental torts, tort law offers two remedies: statutory fines and injunctions. These remedies have been well described and offer many opportunities for in-depth discussion and reform of legal principles. These remedies are founded on the concepts of retributive justice and deterrence in several common law jurisdictions. Now let's see the nature of environmental torts in India. The principles of tort law used to address environmental offences have been derived from concepts of distributive justice, compensatory punishment, punitive punishments, and economic interests in common law countries as well as in the contemporary Western world in many manners. The below illustrations demonstrate the authentic capacity of environmental torts in protecting and sustainably using the environment. The first one is, like in the event of an error or mishap, the tort rule comes into play. Moreover, the tort system may be implicated in cases of environmental lawsuits where there is damage to the environment. Emphasis is placed more heavily on treatment than prevention. The main focus is on compensation rather than deterrence. Damages rather than risks are the acknowledged basis of tort law. This statement is not universally accurate. One important factor in determining carelessness is the likelihood of the damage occurring. The core notion of enforceability is intricately connected to the risk. In general, tort liability refers to liability based on fault, usually involving negligence. According to the concept established in the case of Rylance versus Fletcher, in order to be held responsible, it is necessary for the damages to be predictable. A common misperception is that the concept of pollution compensation necessitates strict liability. Now let's see the difference between environmental law and environmental torts. Environmental law and environmental torts are distinct legal concepts that pertain to different aspects of environmental issues. Environmental law refers to the body of legal rules and regulations that govern the protection and conservation of the environment. On the other hand, environmental torts are civil wrongs or injuries caused by individuals or entities that harm the environment, resulting in legal liability and potential compensation for damages. In environmental law, the need to provide evidence on the causation between two events is altered when it concerns hazardous waste, distinguishing it from environmental torts. In tort trials, the burden of proof lies on the plaintiff to demonstrate that the action caused damages. The majority of tort lawsuits regarding environmental deterioration in India may be categorized into four primary categories. One is nuisance, next is trespass, third one is negligence, and last is strict liability. In this particular lecture, we are specifically talking about nuisance. So let's find out what is nuisance. A nuisance refers to something that causes annoyance, harm, or is objectionable. In accordance with the principle of common law, a nuisance occurs when someone's rightful ownership or rights pertaining to a piece of land are unlawfully disrupted. Nevertheless, for the interference to be considered an actionable nuisance, the defendant's activities must be deemed unreasonable. A nuisance can be classified as either public or private. Therefore, any behaviors that undermine an individual's comfort, well-being, or safety are considered nuisance. Possible sources of interference include odors, noise, fumes, gas, heat, smoke, germs, vibrations, and other similar factors. The defendant's use of the land has resulted in an unjustifiable and avoidable disturbance, thus constituting the basis for a private sector lawsuit for annoyance. A public nuisance is legally defined as an action or failure to act that significantly diminishes the reasonable comfort, convenience, health, safety, or overall well-being of a group of people. It may also be described as an unwarranted infringement against a right that is commonly held by the general population. Some of the activities include trades that generate noxious smells, intolerable sounds, dust, vibrations, and the buildup of filth that deteriorates the livability or health of the environment. Now let's look into certain case laws relating to nuisance and environment pollution. The first one is St. Helens Smelting Company versus Tipping. This case included the plaintiff's trees and shrubs being damaged by the defendant's emissions from their industrial activities. The court determined that the damages in question amounted to property damage, therefore providing grounds for legal action. Any harm that is deemed reasonable will be enough to establish a case for property damage. The second is Delaware Mansions Limited versus Westminster City Council. The party being accused in this case was the proprietor of a tree that was growing in a pedestrian pathway on a public road. The tree's roots caused the neighboring structure to develop fractures. After the cracks were found, the person who took over the building was considered eligible to receive payment for the necessary expenses to fix the damage caused by the continuous irritation from the trees. The third case is Ram Baj Singh versus Babulal. In this case, one individual installed a brick grinding apparatus in close proximity to a doctor's office. The equipment emitted excessive noise and dust, polluting the air and causing difficulty to both the doctor and his patients in the consulting room. As to the Allahabad High Court, an act can be considered a private nuisance if it can reasonably be argued that it causes annoyance, harm, or distress to an individual. Noise pollution occurs when individuals are exposed to high amounts of harmful and disruptive noise against their will. It is commonly known as a disruptive annoyance, and hence it is regulated under tort law. As per the Constitution, citizens are prohibited from exercising their basic freedoms in a manner that causes annoyance to others or pose a health hazard. The fourth case is Free Legal Aid Cell versus Government of NCT of Delhi. In this case, a collective of public activists lodged a petition in the public interest. The main grievance in this petition is that both adults and children are subjected to hazards to their physical and emotional well-being due to the use and exhibition of pyrotechnics during festivities and weddings. Furthermore, it has been said that the reckless use of loudspeakers has resulted in the frequent manifestation of noise pollution, which detrimentally affects individuals' physical and emotional well-being and is a source of irritation. The Delhi High Court aptly observed that the judiciary has not adequately addressed the question of the impact of noise on health. Noise can be classified as a pollutant due to its ability to pollute the environment, create annoyance, and have detrimental effect on an individual's health when it surpasses a tolerable threshold. The fifth case is V. Lakshmipati versus State of Karnataka in the year 1992. In this case, the petitioners expressed their dissatisfaction with the placement and functioning of factories and industrial businesses in a residential zone, which they said was a clear breach of Karnataka Town and Country Planning Act of 1961. Pollution is the act of improperly contaminating the environment, resulting in physical harm to an individual. The petitioners raised concerns about the installation and functioning of factories, workshops, and factory sheds, as well as the distillation method employed for the manufacture of greases and lubricating oils. They also questioned the respondents' manufacturing of flammable items inside a residential zone, citing these instances as indications of industrial activity. The Karnataka High Court mandated the discontinuation of these operations and further ruled that residential areas specifically allocated for such uses should not be exploited. Furthermore, the court mandated that the authorities eradicate any trespasses on public lands and roadways within the impacted area and carry out the court's directive within 60 days of being provided with a copy of it. Furthermore, it was determined that the individuals who filed the case were eligible to receive a sum of Rs 3,000 as compensation for their expenses from the individuals they filed the petition against. The sixth case is Kuldeep Singh versus Subhash Chandra Jain. The plaintiff in this case expressed worry that the opening of the bakery would result in discomfort due to the neighbor's 12-foot chimney and baking oven. The Supreme Court made a distinction between a prospective irritation and a current nuisance. In the instance of a potential nuisance, the court does not need an absolute certainty as proof. However, the plaintiff must provide a compelling argument demonstrating a high likelihood that the harm will indeed happen before the court can interfere. If the potential harm is not sufficiently clear or immediate to result in legally actionable damage that may be stopped by a court order, the mere chance of harm will not provide the plaintiff with the grounds for a legal claim. The complaint was dismissed when the court concluded that the plaintiff's claim, alleging that the baker's smoke would create a nuisance, lacked supporting evidence in both the pleadings and the facts. The next case is Broadbent versus Imperial Gas Company. The court issued an order to cease gas production by the firm in a manner that might damage the plaintiff's garden crops due to the release of harmful substances in close proximity to the plaintiff's land. The individual bringing the legal action is a horticulturist who cultivates and sells produce. The next case is Halsey versus Esso Petroleum Company Limited. In this case, the plaintiff's residence was exposed to acid vapors, namely sulfate, which were observed emanating from the defendant's depot. The depot in question handled fuel oil and had chimneys extending from the boiler building. The plaintiff presented evidence that the smuts and damaged the clothes he had hung outside to dry in his garden, and that the paintwork on his car, which he had parked on the highway in front of his house, had been affected. Despite the strong and nauseating smell of oil emanating from the depot, the plaintiff did not suffer any health effects. The smell was not just a faint background odor, but rather strong enough to disturb even the most sensitive individuals. Additionally, the constant noise from the boiler throughout the night caused the plaintiff's windows and doors to vibrate, making it impossible for him to sleep. The plaintiff initiated legal proceedings claiming that the presence of acidic odors, excessive loudness, and unpleasant smell were causing annoyance. The case held the defendants responsible for any noise, foul odor, or acidic emission that were discharged. A nuisance is typically described as a source of annoyance, discomfort, or aggravation. When considering the environment, nuisance refers to the illegal disruption of the use or enjoyment of land, property, or associated rights. Additional examples of nuisance include water leaks, smoke, odor, gas leaks, noise, vibrations, heat, and similar disturbances. It may perhaps be the things that irritate others. In the case of Dhanalal versus Thakur Chittar Singh Mehtab Singh, 1959, the MP court determined that noise might indeed be a source of irritation. Again, in the case of Ram Ratan versus Munna Lal of the year 1959, it was determined that noise can be considered a kind of pollution and annoyance if it substantially disturbs an individual's usual degree of comfort. So to conclude, it may be inferred that the advancement of tort law in relation to environmental pollution has enabled affected persons to seek reparation for the harm caused. Furthermore, it has issued a cautionary notice to firms that engage in the handling of hazardous substances. The process of evolution has facilitated the advancement of judicial administration. The notion of absolute liability, which is unique to Indian law and not derived from English law, requires further development to provide more responsibility and protect rights through appropriate remedies and compensation. It is widely recognized that endangering someone's life is a grave offense that is never justified. With this, we come to the end of our today's lecture. Thank you very much.